activities which they feel are their province and sole domain. Now, the Legal Profession Act is what they point to, and a certain section within it, and they use that. They're kind of tricky. What they like to do is they'll come and they'll point to this act and they'll say, we want you to enter into an agreement with us that because of this act you're bound from engaging in a certain course of action. And once they get that agreement, then they go and they seek a court order enforcing that agreement. If, however, you stand your ground and you say that act has nothing to do with me, then they're a little bit miffed, but there's very little they can do about it. Now, this is the section that we are going to be examining to determine whether or not this act is applicable. It's actually the very first part. It's section 1.1. And here, let's read it together. It says, this act does not apply to a person who is both a lawyer and a part-time judicial justice, as that term is defined in Section 1 of the Provincial Court Act, in the person's capacity as a part-time judicial justice under that act. That's all it says when it refers to the application of the Legal Profession Act. Now let's examine it using the high-tech board of truth and justice, and let's figure out exactly what's being said, and let's figure out to whom this act can be lawfully applied. And let's see whether or not that body of people includes those who are not lawyers. That's the question. So, according to the act they point to, all they really tell you is this: this act does not apply to a person who is both a lawyer and a part-time judicial justice, as that term is defined within a certain place, provided they're acting as a judicial justice. So let's look at what we have. One is the application of the act. That we will represent with an A. A equals act applied. It speaks of lawyers, who is both lawyer. So we'll use an L to represent a lawyer. And then it refers to a judicial justice. A judicial justice. Now, they give an exemption here clearly to people who are lawyers and judicial justices. So why would they do that? What is the purpose and reason for the exemption? There has to be one. And we must keep it in mind because we're going to branch off later, look at two different arguments or interpretations of this, and then we're going to determine which one is proper and correct by examining this original purpose. What was in fact the original purpose of this exemption? So we'll put that up here. Why? Which is the purpose. Now you speak to any JP or judicial justice, and they'll tell you quite likely the reason is, the purpose of this exemption is so that they can enjoy judicial immunity and do their jobs properly. Now I'm sure we'll all agree that all judicial justices, all of them, must enjoy the same level of the judicial immunity. Okay? So a judicial justice, all of them, they must be treated equally. JJs are always equal. So now let us look at the math that we find here within this section. We know that this act does not apply to a person who is both a lawyer and a part-time judicial justice. So, what we know is not A. This act does not apply, not A, to a person who is both a lawyer and a part-time justice. And I write that as not A if L plus J. The act is clearly not applicable if you're a lawyer and a judicial justice. That's what it says. So we know then, we'll look at the opposite of that, not A, but there must then be A if L, but not JJ. Now the argument of the Law Society is that this act is applicable to everyone, even though the term everyone is not used in the section that deals specifically with the applicability of the act. They want you to assume this and to operate upon this presumption, but there is nothing here that supports it, and it doesn't create the implication as the following does. In order to figure out what the truth is, let's remove the negatives here. They've burdened it with negatives. So if you remove the not JJ, then you will get that it is applicable if they are a lawyer, but not if they are a lawyer and a JJ. Now let's examine this to see whether or not it holds logical water. Remember, a judicial justice, they must enjoy this immunity, and all judicial justices must be treated equally. But some judicial justices are not lawyers, and if we accept the interpretation that the Law Society wants us to accept, then what you end up with is something that looks like this. It took up too much space. They would want you then to assume that it is applicable to all unless you are a lawyer who has been appointed by a JJ. And that would write as A equals, or A if not, L plus JJ. However, there are judicial justices of the peace who have never been lawyers, and therefore, based on their argument and simple rules of logic, if not A if L plus JJ, then A if not L plus JJ, then that means A if not L plus JJ, and that means A if JJ but not L. And that means there would be judicial justices out there who have never been lawyers who would be subject to this act because they don't fall under the definition of someone who is both a lawyer and a part-time judicial justice. They're merely just a judicial justice. And according to the Law Society's interpretation, they would then be subject to the act. But that means they no longer enjoy the judicial immunity, which was the very reason for the original removal of these people from being subject to the act. The only proper way you can interpret this is that this act is in fact applicable against lawyers, and only lawyers, unless they are in fact been appointed as a part-time judicial justice. There's no way to interpret it as saying that it applies to everyone unless they are a lawyer appointed to a judicial justice position, because then they include those people who have been appointed to the judicial justice position but have never been a lawyer. And the reason for the exclusion of this is then denied those people who have never been a lawyer.